Hi, my name is Ricky LeBlanc. I'm the managing attorney at Sokolove Law. Can Depo-Provera cause brain tumors? The simple answer is that there is a connection that has been found through scientific studies between the use of Depo-Provera and the development of brain tumors. First, let me be clear. I'm an attorney, not a doctor. A major study published in the British Medical Journal found that women who used Depo-Provera for a year or more were allegedly over 5 times more likely to develop what's called meningioma. That's a type of tumor that forms in the tissues surrounding the brain or spinal cord. In fact, today over 3,000 people have filed claims based on their development of brain tumors through the use of Depo-Provera. What symptoms should women watch out for? That's one of the most important questions someone who used Depo-Provera shots can ask. And I want to answer it carefully because I'm not a medical professional and I'd always encourage anyone to speak with their doctor first. If you received Depo-Provera shots, you should be looking out for symptoms such as dizziness, lightheadedness, chronic headaches, even loss of memory or use or functions of the extremities, arms and legs. You may even develop seizures. These are serious medical conditions, and if you've been using Depo-Provera, you should consult your physician immediately if you experience any of these symptoms. The reason these symptoms can be so easy to miss early on is that meningiomas tend to grow slowly. It can take time before they press on the nerves or brain tissue enough to cause noticeable problems. It may be nothing, but we've had clients tell us they dismissed those warning signs for a long time, and looking back, they wish they hadn't. How would someone know if the meningioma is connected to Depo-Provera? You can't know that on your own, and I wouldn't expect anyone to. Proving that kind of connection requires medical expertise, scientific evidence, and a thorough legal investigation. If your doctor didn't tell you, or if you haven't seen this video, you likely would have no way of knowing the connection. Be certain that your doctor knows your medical history and your use of Depo-Provera, along with any symptoms you're experiencing. And you should call Sokolove Law so that we can review your medical records and your medical history to determine whether or not we would want to look into this further and seek medical opinions that connect your use of Depo-Provera to your symptoms. We can't guarantee what we'll find, but if the facts are there, we'll find them. When people ask me whether they should take legal action over the use of Depo-Provera in their development of meningioma, I really say there are 2 answers to the question. Firstly, take that action because treatment for your disease can be expensive. You also may have lost time from work and incurred other damages. As a result, you should be compensated for that. The second reason, and perhaps it's even the more important reason, according to the lawsuits, Pfizer allegedly knew, or at the very least should have known, about the potential link between Depo-Provera and meningiomas for years. Meningioma warnings had already been added to the Depo-Provera labels in Canada and the European Union. But here in the United States, nothing until the FDA finally approved an updated warning label in late 2025. When companies put profits ahead of people, your claim will take some of those profits away and perhaps will change the behavior of the companies. People often ask me what evidence is needed to pursue a Depo-Provera lawsuit. At that point, my answer is simple and always the same. Whatever the evidence is, that's the job of your attorneys to develop. It should not be something that prohibits you from placing the call to us to find out if you have a case. In every instance, always call us first and we can answer any questions you have about evidence or any other part of a Depo-Provera claim. It is always helpful if when you contact us, you know the names of your doctors and the places where you received any treatment or diagnosis. If there's any imaging studies or any other tests, just let us know. The first thing in a Depo-Provera case that we need to do is prove that you actually used Depo-Provera. Depo-Provera is a shot that you received in your doctor's office, so we likely won't have any pharmaceutical receipts. What we will have is medical records from your doctor that will show that you regularly received these shots. Once we've established that you received these shots, then we need to establish evidence of injury. If you have a meningioma, then there should have been some clinical records, that is, notes from your doctor describing your symptoms, and likely some testing, most likely imaging, and we would gather those as well. Once we have the evidence of use and of injury, we would provide those to a medical expert and ask for an opinion that the two are related. But honestly, even if you don't have all of that in hand, reach out anyway. The first step is just a conversation. Again, it's important to remember, the gathering of the evidence is our job, not yours. So contact us immediately and we will start working on your case right away. How long do women have to file a Depo-Provera lawsuit? The answer is not a simple one, except to say there is a deadline for everyone. The question of how long someone has to file a Depo-Provera lawsuit is one I feel strongly about, because the answer affects whether you have any legal options at all. Laws in each state vary. They are called statutes of limitations. If you miss the statute of limitations, you are forever barred from making your claim. You can recover nothing. Some states have laws that limit the time frame to a small amount of time, such as 1 year. Others allow multiple years. And in some states, the calculation of that time begins the day you were diagnosed. And in others, there's what's known as the discovery rule, which means the timing of that doesn't begin until you knew or you should have known there was a connection between your symptoms and your use of Depo-Provera. In any event, the only way to figure this out is to call us. Do not think it's too late, and do not wait because you think you have more time. You should call us immediately. A lot of people want to know what the process of filing a Depo-Provera lawsuit is actually like. Frankly, most people have never been involved with the court system and certainly haven't filed a lawsuit. All claims or lawsuits start with the initial consultation with our office. That's when we look at your medical records and medical history. We hear about your symptoms. And then we just make the decision whether or not this is a case we can pursue. That's the end of it for you. The rest of it's on us. After that time, we will gather all of those medical records and all of the records of any symptoms or treatment you received and your use of the Depo-Provera. All the things we talked about in our initial consultation. Once we receive all of that documentation, it's what we will use as evidence to present your case in a court of law. Before we get there, though, we will have an expert medical professional review the records and determine that the use of your Depo-Provera was the cause of your meningioma. Once we have that, the case will be filed and the litigation will begin. Again, all of that is by us. You will occasionally be kept informed about what's going on, and we may seek further clarifying information or additional information to pursue your case. During this time when we're gathering all of your records, you can rest assured that there is no risk on your part. We work on a contingency basis, which means you don't pay us anything up front, and you only owe us anything if we secure compensation for you. If we don't win, you don't owe us a thing. I hear that question often. What's my case worth? How much compensation will I receive for my Depo-Provera claim? The simple answer is, I don't know. Nor does any other person involved in this litigation. It's just too early. When we first meet and you provide us with your information, we have an understanding as to whether or not we want to pursue your claim based on the facts you presented. It doesn't mean there will be a recovery, although we wouldn't take a case if we didn't think there would be. But no one can put a value on it in those early stages. There's no single number that applies across the board because the value of a claim depends on factors specific to you. How many injections you receive, the size and location of your tumor, how this has affected your daily life and your ability to work, your medical expenses, what your future care looks like. All of those factors are unique to every single case. In addition, the science has to support your claim. And so, working with experts, we need the connection. If they connect your use of Depo-Provera with your disease, which is likely, then you have a better chance of recovery. But the amount of that recovery is going to be an unknown until we get closer to resolution. The important thing is, this is your case. So no matter what the value of it, no matter what the value that somebody else puts on it, when the time comes and a settlement offer is made, it'll be solely your decision. We'll give you guidance and we'll give you counsel, but you have to make the decision whether or not that money is right for you. And if it is, then your case is resolved. But what that value is, we won't know until then. Is the Depo-Provera lawsuit a class action? I'm asked that question often, not just unique to Depo-Provera, but anytime someone calls and wants to know about their particular claim. The easy answer is that the Depo-Provera lawsuit is not a class action. It's what's called a multi-district litigation, which right now is being handled in the Northern District of Florida. After that, your case may be tried there or in another federal district court. How does that differ? In a class action, which you may have heard about in other instances, one plaintiff, meaning one person who was injured, stands before the court as a representative for all people who are injured, which means you don't get to stand there and present your case, only they do. And if they win, you win something. If they lose, you also lose. In multi-district litigation, all the courts have done is taking your individual claim that you filed and that you get to present in court and put it together with all of the other people in the country with the same claims. Now, that sounds like a class action perhaps. It's not, because the court has only put them together, the plaintiffs, meaning the people who are injured, and the defendants, meaning the company who created the prescription that injured you, can speak with one another and perform the administrative parts of a case prior to the trial. Things like exchanging information with one another, what they knew, what we have for medical records, etc. Once that's complete, and it's time for a trial, each plaintiff will individually have the right to present their case one at a time. It's not a class when someone's representing you and you get whatever they get. You present your case yourself, and whatever the jury or judge decides is your verdict. You're not reliant on someone representing you. Whether Pfizer knew the risks from using Depo-Provera is a central issue in this litigation. And frankly, this is the part that makes me angry. According to the science, Pfizer knew or should have known of the increased risk of developing a meningioma from the use of their drug. This drug contains a synthetic hormone. That hormone, in studies, is believed to increase the likelihood fivefold, meaning you're 5 times more likely to develop a meningioma. How long did Pfizer know this? Well, there are studies going back to 1983. And in fact, for years, they have warned women in other countries, the European Union and in Canada, about this risk. But in the United States, the FDA didn't approve that label warning until 2025. So yes, Pfizer knew about these risks. What is the latest on the Depo-Provera litigation? Well, the simple answer is there's a lot going on. And every month, hundreds of more cases are being filed in the MDL. The FDA's decision to approve a meningioma warning label in late 2025 is significant. In my experience, when a regulatory agency formally acknowledges that a risk is real enough to put on a label, it can change the dynamic of the litigation and encourage the manufacturer to have more serious conversations about resolution. But we are still in the early stages of this litigation, so there have not been settlements or those kind of discussions at this point. Right now, the discovery is going on, meaning we're exchanging information between each party. But what's happening in MDL can change rapidly, so always continue to check in the litigation. And whatever you do, if you haven't already filed a claim or spoken to an attorney, you should do so immediately. Give us a call, and we'll determine whether you should be joining the MDL as well.